Good evening, everyone. This is Venemay Celeste, and I will continue the reporting on the obligations and rights of the warehousemen upon their receipts under Section 9 to 28 of Warehouse Receipt Act. Once a warehouse receipt is issued, to whom should warehousemen deliver the deposited goods? Under Section 9 of this Act, the warehouseman should deliver the goods to the following: 1. Person lawfully entitled to the possession of goods or his agent. 2. To persons entitled to delivery under a negotiable receipt, non-negotiable receipt, or with written authority. And 3. A person in possession of a negotiable receipt. And please note that negotiable receipt is a receipt in which it is stated that the goods therein specified will be delivered to bearer or to the order of a named person. Now, what if there is misdelivery of goods? What is the warehouseman's liability? Section 10 provides two liabilities. One, liability similar to bank paying forged check. Here in the case of Samsung Construction Company, Philippine Incorporated versus Far East Bank and Trust Company, the general rule is to the effect that a forged signature is wholly inoperative and payment made through or under such signature is ineffectual or does not discharge the instrument. If payment is made, the drawee or the bank cannot charge it to the drawer's account. The traditional justification for the result is that the drawee is in superior position to detect a forgery because he has the maker's signature and is expected to know and compare it. In the same way as a general rule, the warehouse receipt is not discharged when there is misdelivery of the deposited goods. Second is liability as for conversion. Here, there is an authorized delivery. The liability is as for conversion or unauthorized assumption and exercise of the right of ownership over goods belonging to another through the alteration is as for conversion. Note that even if the warehouseman delivers the goods to person entitled to delivery under a non-negotiable receipt or with written authority or person in possession of a negotiable receipt, he may still be liable for conversion if prior to delivery he had been requested not to make such delivery or he had received a notice of adverse claim or title of a third person. Now let's proceed to sections 11 and 12 of this Act. These two sections provides for the cancellation of receipts on delivery of goods. Under section 11, the receipt must be canceled, and under section 12, the receipt must be either canceled or marked as to that part of goods delivered. Note that under section 11, the negotiable receipt must be one, the negotiation of which would transfer the right to the possession of the goods. Now, what is the effect of alteration on liability of warehouseman? It depends on the nature of the alteration. Section 13 provides that 1, if the alteration is immaterial, example is when the tenor of the receipt is not changed, like the substitution of the real name of a party, whether fraudulent or not, authorized or not, the warehouseman is liable on the altered receipt according to its original tenor. Second is if the alteration is immaterial, example of which is if the tenor of the receipt is changed, like the erasure of the name of a party and the insertion of another, but authorized, the warehouseman is liable according to the terms of the receipt as altered. Third is if the alteration is material but innocently made, though unauthorized, the warehouseman is liable on the altered receipt according to its original tenor. And fourth, if the alteration is material and fraudulent or fraudulently made, the warehouseman is liable according to the original tenor of the receipt to a purchaser of the receipt for value without notice, and even to the alterer and subsequent purchaser with notice, except that as regards to the last two, the warehouseman's liability is limited only to delivery as he is excused from any liability. Note that under this section, it is clear that even a fraudulent alteration cannot divest the title of the owner of stored goods, and the warehouseman is therefore liable to return them to the owner. Now, what if the warehouse receipt was lost or destroyed? Under Section 14, a competent court may order the delivery of the goods, but only upon proof of the loss or destruction of the receipt and upon the giving of the bond with sufficient sureties to be approved by the court. Now, to continue, what if there are several claimants of the deposited goods? What is the obligation of the warehouseman? Under Section 18 of this Act, the warehouseman must determine within reasonable time the validity of the conflicting claims. Second is he delivers to the person whom he finds is entitled to the possession of the goods. Third, he must bring a complaint in interpleader and require the different claimants to litigate among themselves. He will be relieved from liability in delivering the goods to the person whom the court finds to have a better right. To better understand, here is the case of KIAN versus Manila Railroad Company and the Manila Port Services. The facts of the case is that a arrastre operator received into its custody a shipment of 5,000 cases of milk, of which 3,171 cases were marked for B as consignee and 1,829 cases were marked for C. But according to the bills of lading in A's possession, B was entitled only to 3,000 cases and C to 2,000 cases. A actually delivered 1,913 cases to C, which is only 87 cases short of 2,000 cases as per bill of lading. Now, the issue of this case is that is A liable to C for the undelivered cases of milk? The ruling of the court here is yes. The legal relationship between arrastre operator and the consignee is akin to that of a depositor and warehouseman. As custodian of the goods discharged from the vessel, it was A's duty, like that of any other depositary, to take good care of the goods and to turn them over to the party entitled to their possession. In this case, A should have withheld delivery because of the discrepancy between the bill of lading and the markings and conducted its own investigation, not unlike that under Section 18 of the Warehouse Receipt Law, or called upon the parties to interplead in order to determine the rightful owner of the goods. Now, Sections 18 and 21 provides other liabilities and obligations of warehousemen. What are these? First, his liability to rightful owner. Where a warehouseman does not compel interpleader in a case requiring it, he is liable for refusal to deliver the rightful claimant. And where he neither interpleads nor investigates, he will be held guilty of conversion as of the date of original demand of the goods. Second is his liability for loss of goods. Note that in the absence of agreement, warehousemen are expected to take custody of the goods with the diligence of a good father of a family. Thus, the warehouseman is not liable for any loss or injury to the goods, which could not have been avoided by the exercise of such care. Now, in relation to commingling of goods deposited, are warehousemen allowed to do so? As a general rule, a warehouseman may not commingle goods belonging to depositors under Section 22 of this Act. In the case of fungible goods, however, like rice, sugar, etc., the warehouseman may mingle them with the goods of the same kind and grade, provided that he is authorized by agreement or custom, as provided for under Section 23 of the same Act. In that case, the different owners under Section 24 become co-owners of the whole mass. Note that the Civil Code provides that unless there is stipulation to the contrary, the depositary may commingle grain or other articles of the same kind and quality. Now let's proceed with section 28, which provides for goods subject to lien. For goods belonging to depositor or his principal, under section 28, the warehouseman may enforce his lien against the goods of the depositor who is liable to the warehouseman as debtor whenever such goods are deposited, and also against goods of other persons stored by the depositor who is liable to the warehouseman as debtor with authority to make a valid pledge. The purpose of the law is, in the second case, is to give the warehouseman a lien for charges against the goods or persons who are primarily liable for the charge incurred and who by their agreement create the relation of debtor and creditor. As to the goods stored in fraud of true owners' rights, there is nothing in the act giving a warehouseman a lien on goods belonging to another and stored by a stranger in fraud of the true owner's right. Otherwise, a warehouseman could become a legal receiver of stolen goods, at least to the extent of the charges. That's all for my report. Thank you for listening.